Before we talk about what the law of evidence is, let's go over why it's needed. Evidence law is peculiar to what we call the adversary system of justice. It's also unique within that system because it makes a lot of small procedural as well as big substantive decisions about how power is allocated to resolve legal controversies fairly and accurately. The adversarial system is also known as the common law system. The other major Western system of justice is the civil law or inquisitorial system. Both of these are ancient. The civil law system traces back to the 6th century Eastern Roman Empire. The common law system emerged 600 years later in Great Britain under King Henry II. In countries with an adversarial system, judicial decisions are declarations of law, while in an inquisitorial system, only the codes or statutes are the law. Each party to a common law case investigates, gathers evidence, finds witnesses, and decides how to make the best case to a neutral court. Inquisitorial judges are specially trained to investigate the case and decide the facts for themselves. The jury is the most important distinguishing feature of the common law. It is for the jury's sake that we have a law of evidence. Evidence law is rooted in the common law principles that have decided what juries get to hear and what they don't get to hear for hundreds of years. The overriding goal of evidence law is to get the jury to put aside its fears, prejudices, affinities, biases, and other baggage, and to decide what happened based only on the facts that logically matter. Evidence law tries to encourage the jury to be as rational and logical as possible. We want verdicts that are the product of reason, not emotion or other irrationalities. Britain made it a point to instantiate the common law among its colonies. The common law jurisdictions are all former British or United States colonies, and their legal systems are built on the same ancient principles. This is why big law firms in the US and the UK are able to confidently outsource legal work to, for example, India. The federal rules of evidence apply in both civil and criminal cases in federal court. Since 1975, when the rules were enacted, many states have passed evidence codes based on the federal rules. Usually, the state rules are numbered to correspond to their federal counterparts. Because of the higher stakes and the constitutional rights implicated by criminal prosecutions, some rules apply differently to criminal cases than to civil ones. So it's helpful to know the major differences between the two types of cases. Any legal person can bring a civil case by filing a complaint. That includes humans, for-profit corporations, non-profit organizations, and governments. In a common law jurisdiction, only a federal, state, or territorial government, a sovereign, can indict or charge someone for a crime. That means that you can't tell a civil case from a criminal one from only its style. A case styled United States versus the defendant might be a suit for money from a breach of contract to provide goods or services to the government, or it might be a criminal prosecution. A civil plaintiff usually sues for money as compensation for a claim. They sometimes sue for equitable relief. In either case, the plaintiff seeks to rectify harm that the defendant inflicted on him, either deliberately or carelessly. The sovereign brings a criminal case on behalf of all the people to impose consequences on someone who intentionally broke society's rules. The sovereign seeks to take the defendant's life, freedom, or property not as compensation, but to punish or rehabilitate the lawbreaker. Civil cases are decided in favor of the party whose version of the facts is the more persuasive. Criminal verdicts depend on whether the government proved that its allegations are undoubtedly true. The burden of proving guilt beyond a reasonable doubt is guaranteed in all prosecutions, whether federal or state, by the 5th and 14th Amendment due process clauses. The 5th and 14th Amendments also exempt criminal defendants from the duty to testify, which the common law imposes on everyone. We say a defendant is privileged not to testify because a legal privilege is the opposite of a legal duty, and the default common law rule is that everyone is obliged to testify when summoned. Witnesses who refuse, without the protection of a legal privilege, commit contempt. The Sixth Amendment applies specifically to criminal prosecutions. Its double jeopardy clause prevents the government from appealing an acquittal. An acquittal is final, and the jury never has to explain or justify it. The Sixth Amendment does not apply to civil cases at all. The jury is the main institution of common law justice, and trial by jury is guaranteed in both civil and criminal cases. The Sixth Amendment guarantee is more strictly applied than the Seventh Amendment one. For example, in civil cases, the court can enter judgment summarily for either side if it decides that there are no factual disputes for a jury to resolve. However, because of the Seventh Amendment, summary judgment can be granted only on the basis of legally admissible evidence. There is some academic controversy over whether summary judgment is constitutional even in civil cases, but it has never been doubted that there is no summary judgment in criminal cases. Facts in a criminal case can be established in only two ways. The defendant admits the facts, or the jury finds the facts. Judges in criminal cases cannot make any fact findings. The Sixth Amendment also guarantees criminal defendants a lawyer at public expense if necessary. There's no corresponding right to appointed counsel in civil cases. The Advisory Committee selected to draft the Rules of Evidence published its final draft in November 1972. It was immediately controversial. Before then, there was no federal evidence code, although some states had one. One of the main points of controversy was that the Advisory Committee's proposed rules gave the executive branch discretionary power to withhold evidence by invoking national security or another public interest. This came at a time when the Watergate scandal was exposing President Nixon's baseless claims of privilege. Justice William O. Douglas dissented from the order transmitting the proposed rules to Congress. Justice Douglas did not believe that the Rules Enabling Act authorized the court to sponsor the rules of evidence. The act covered only procedural rules, and evidence is substantive as well as procedural. He also did not believe that the Supreme Court should have any involvement in the promulgation of the rules. Two decades later, when Justice Antonin Scalia dissented from some civil procedure rule changes, Justice White shared that Justice Douglas had not been alone. He claimed other justices, himself included, agreed that the court's involvement in the rulemaking process gives a false impression that the court has determined the rules to be lawful. All of this is to say that the rules have been controversial from the start, and in some aspects remain so today. Rather than allowing the proposed rules to go into effect, Congress undertook detailed studies of them. Eventually, the House and Senate Judiciary Committees submitted reports citing cases, legal treatises, and law review articles, and making substantial changes to many of the proposed rules. A joint conference committee harmonized the House and Senate versions, resolving conflicts between them. The rules did not go into effect until 1975. This means that the legislative history of the rules is spread across these four reports, which are included in most commercial printings of the rules, along with notes pertaining to revisions made by subsequent advisory committees and Congresses. In the case of Rule 301, for example, the House watered down the advisory committee's proposal that presumptions count as evidence. The Senate rejected the proposal outright, and the conference committee sided with the Senate. The Senate relied on California Justice Roger Trainor's dissent in a 1942 case. Justice Trainor maintained that a presumption changes only which side presents evidence first. Presumptions are not themselves evidence. They matter only if the party against whom the presumption applies lacks some evidence on point. If the presumption is rebutted, it falls from the case, and each side's evidence is weighed as usual. Trial begins with some process for selecting an impartial jury. How that is done varies across jurisdictions and from judge to judge. Once the jury is sworn, the party with the burden of proof delivers its opening statement, and then the defense follows suit. The openings introduce the evidence that the parties expect the jury will see and hear. Although argument is technically improper, the adversary system encourages each side to do what it can to begin bringing the jury around to its view of the case. The plaintiff or the sovereign then presents the case in chief by calling one or more witnesses. After each witness's direct examination, the defense has the opportunity to cross-examine, and that may be followed by a redirect examination. This pattern repeats until the plaintiff's or the sovereign's witnesses are exhausted, at least in the sense of there being no more to call. The defense then presents its case, if it chooses to present one. The defense case proceeds the same as the case in chief, except that the defense does the direct, the plaintiff or sovereign can then cross-examine, after which the defense can redirect. This gets repeated for each subsequent witness. The rebuttal case, if any, follows the same pattern as the case in chief. Finally, after the evidence is in, we get to the closing arguments or summations. Mirroring how the evidence is presented, the party with the burden of proof again goes first and last. The defense closing is heard in between the plaintiff's or sovereign's closing and rebuttal closing. Before the jury retires to deliberate, the judge will instruct the jury on the law. The parties will have had an opportunity, either before or during trial, to argue any disputes about what instructions ought to be given and how they ought to be phrased, based on precedent. The jury's deliberations are absolutely secret, but the jury can send notes out for clarification about the evidence or the law. If they do not reach a verdict, the case can be tried all over again to a new jury. If they reach a verdict, it is published, meaning it is announced in open court. Before, during, and after trial, the parties file a series of motions to get evidence in or out, to demand judgment on legal grounds, and to preserve objections for appeal.